buenos días. Empezaré agradeciendo al Open de Arbitraje esta posibilidad de reaparecer de nuevo ante ustedes. Javier Íscar, eres un fenómeno organizando este tipo de eventos. Has conseguido realmente una audiencia donde no solo por el número, sino precisamente por la calidad de los asistentes, es realmente espectacular. Enhorabuena, como siempre. El arbitraje siempre ha sido un fenómeno en los últimos 15 o 20 años revolucionario en España en materia jurídica. Siempre ha aportado soluciones y novedosas construcciones, y una de ellas hoy es la financiación de los litigios, y no solo de arbitraje, sino también de los litigios como consecuencia del arbitraje. España hoy es quizá el plato deseado de todos estos fondos internacionales que se dedican a la financiación de litigios y de arbitrajes. Hoy estamos en el punto de mira y precisamente es muy importante esta reunión hoy con mi cofundador del fondo Calunius, muy activo en España, no solo en arbitraje, sino también en pleitos domésticos. Por eso yo creo que es extremely important to have you with us. We are delighted that you come to us, and as you know, we are in a gathering of really good experts. So you don't need to explain generalities about third-party funding or litigation finance. Let's go to concrete questions. Why a company or a person should request your services?
So I'm going to speak in English, if you permit me, everyone. I thank Bernardo and Javier for the...
She speaks Spanish like a Spaniard, but anyhow.
Yeah. Pero vamos en inglés, ¿no? Mainly because it's great to be here just for the Spanish Inquisition, which this
It's not the Inquisition.
This sort of feels like. So Bernardo asked, why do people with money who can finance their own litigation and arbitration, what are they? The market has evolved now. This is the market that we're involved in is one where there's a lot of money available. It's become a very interesting area for financial investors to invest their money with people like us at Calunius, and then our job is simply to put that money to work in the legal market, and particularly the litigation and the arbitration market. And therefore our job is to help bigger business understand that it makes sense to use our money to take the risk of litigation and arbitration, which is it's a toss of a coin. It's a binary process often, even if you have a good case. Good cases lose. So the proposition to companies with money is, let somebody like us take that risk for you, because that's our job. And our cost of capital for taking lots of litigation risks makes sense for us. We can take that risk, and we can take that risk at a price and a cost that makes sense to companies and businesses like you or your clients, companies with money, but want to make a risk transfer decision.
Some years ago, 10 years ago, I contacted your group to finance different arbitrations in Spain or in Latin America. You refused at that time. Now you are very interested. Why the change?
Well, so there's a story here that Bernardo doesn't actually know, but we had a conflict. We had a conflict because Bernardo is with respect, your firm is quite a small firm, so that if we were to enter into a financing relationship with you and your firm, whilst perhaps also financing an arbitration where you sit as an arbitrator, we might have created a situation of material conflict. So we loved you.
No, I understand that.
Yes.
But at that time, you said that you didn't have the interest in conducting or financing arbitrations in Spanish language. Why the change now?
My Spanish has improved. But better still, we have and he's here today, we have an office here now. We have Antonio. I'm sure you'll ask a question later, but and we're not the only funder who's now active in Spain who have quality local people who you know, the Spanish market is not the London market, it's not the Frankfurt market. It's that's what it is. You need
Are you
local
thinking
expertise.
Expanding your business in Spain?
We are, yes.
Why?
The sheer volume of inquiries we've had. I mean, this year the number of inquiries we've had for Spanish litigation, we're being approached by some of the very largest companies who, with portfolios of litigation and arbitration, and the question for us is not can you finance a case for €1 million, but the question is, I have an award or a judgment for €100 million. Can you finance that for me while we wait for collection or to get past set-aside or appeal proceedings?
Do you buy the award?
Potentially, yeah,
or finance it. Do you think the arbitration award is a financial asset?
We do, yes. With legal risk, which is why we can charge a premium.
Why, or how, who are your clients? Lawyers or companies or individual persons? I mean, who are your main clients?
The people who we talk to most are people like you. It's lawyers who, external lawyers rather than in-house lawyers, who people come to you with their legal problems. They don't, you know, they rarely come to us directly. They pretty much always come via their external lawyers, and the external lawyers are problem solvers and intermediaries to the sources of capital like us. So
lawyers, we are now not only being lawyers, but intermediate with the financing people.
Exactly.
How do we convince you about a case to be financed? Because normally we have the impression when we go to a bank, we have to present our assets, our credibility, our income. I mean, how do we convince you about a case to be financed?
Well, we don't rely on you. So you have a claim and a claimant, and you come to see us, and you say, look, we have this case, we think it's good. And we say, okay, thank you for presenting that, but we go away, we do our own assessment, we instruct our own lawyers, and we rely on their advice to us. So clearly, there's a clear separation. You advise your client, our lawyers advise us, and we conduct our own assessment of the case. And the things the obvious things we care about, obviously the merit of the claim, any jurisdictional risks, the time it's going to take to recover money, the likely damages, not the forensic expert first claim form, the real likely damages. We care deeply about that. And then how likely it is that those elements could change over the time of the duration of the arbitration, say. It could take, is the case dependent on witnesses, or is it more dependent on documents? Documents better, witnesses, quantum, is it a case about real cash flows or real investment that was interrupted, or is it a lost chance case? Lost chance, not so good. Those sorts of things. That's a sort of flavour of how we think about the risk.
So you always rely on the credibility of the law firm presenting the case?
Yes, it's very important. Mm-hmm. But we try to have as many relationships as we can around the world with credible lawyers.
But
and there are lots of credible lawyers.
You are aware, because you were trained by Freshfields, that when a lawyer starts a case, it's convinced that he's right.
Yes.
And you take, let's say, a very cautious position vis-à-vis what the lawyers tell you to do.
Yes. So claimant's lawyer thinks the case is brilliant. Our lawyer thinks the case is, and the answer is usually in there, which is usually good enough still.
Mm-hmm. Do you intervene in the arbitration proceedings? I mean, the question is a deontological problem. I mean, if I am a lawyer, who is my client? The one who instructed me, or the one who pays me the bills, the fund?
Yeah. No, your client is always the claimant. An English law funding agreement is very clear. The claimant is your client. The claimant retains control of the arbitration. In Germany, you can do it differently. You can assign the claim, but the English law model, and we use that for arbitration because we don't want to create jurisdictional problems about whose claim it is. So the line is very clear. We have protections in the funding agreement if we disagree with a proposed course of conduct. We can challenge it and have an independent assessor appointed.
Who appoints the arbitrator? The lawyer or the fund?
In that situation, well, we'd usually choose a panel of one, and then it needs to be agreed, or you go to the appointing authority under usually the LCIA rules for us.
Are you in favor about disclosure? I mean, should someone who is financed in an arbitration proceedings should disclose that he is financed?
We do it regularly. Normally we have done it, we've done it because we're financing a publicly listed company, and they need to disclose they've made a material transaction. They need to tell their investors. So that's common. But apart from that, our approach, and not every fund is the same, but our approach is to avoid any cases where we might have a material conflict of interest with an arbitrator. So disclosure isn't something we think is necessary, but if I was an arbitrator, I would ask. So you have to be ready anyway to disclose.
But we don't get any answer. I've been an arbitrator asking the parties to disclose if they have third-party funding, and I've got many times the refusal to disclose that.
Okay, well, we would.
You know why? Security for costs.
Yes. Well, that's the problem. We have been disclosed, and it has triggered frivolous security for cost applications. And that's the real reason not to disclose. It's just because it can be used as a respondent tactic, raise the costs, make life more difficult for the claimant. Mm-hmm. But sometimes a security for costs application is justified. So there are solutions to that. Mm-hmm. You could have one approach we've had in one of the arbitrations where we were disclosed, we put up security for costs, but the respondent conceded that if it lost the arbitration, it would pay a multiple on that security for costs as a price of losing the arbitration. So it can be done.
How do you calculate your percentage at the end of the day?
It's a function of really of risk and time.
Some tribunals, especially in the States, are coming to the usury, complain about what you are receiving from the pie. Hmm?
It's our argument and our explanation is this is very risky money. I mean, when you invest.
But it's very profitable, because if you see the balance sheet of your colleagues, it's not a bad business.
Yes, no, I agree. I agree. But that isn't a bad thing. But the price of if you have a portfolio of 10 cases and you expect to win 7, the difficulty is you don't know which of the 3 you lose. So for the 7 that you do win, you need to make a multiple of your investment, and that multiple may be 3 or 4 times it. But then it depends how long those investments are outstanding. Are they 3-year investments or 5-year? Or in international arbitration, it can be 7 years until you recover money. Mm-hmm. And then the multiple on your investment you make on the successful cases can be quite large, because you lose cases, you get hit for adverse costs, and you've got to pay the cost of running the business as well. But the cost of our money is not dissimilar from the cost of other large, well-capitalised, utility companies, electricity or whatever. The sort of return on equity that people are looking to make.
Who is behind the fund? Because, normally we expect a decision evaluating a case depending on the psychology of the one who is on the risk assessment committee. Who are really? Are they lawyers? Are they financiers? Where do they come from?
Well, in our business, there's sort of, we're a group of 6 or 7. We have an internal investment committee, but we have a traditional fund structure. So the business in London makes the investment recommendations to the fund, and the money is, in our case, it's managed in Guernsey, but it could be in other jurisdictions. And the fund board in Guernsey has its own independent board, but the bulk of the decisions are taking their pursuant to the advice that we give them. So there isn't anybody behind us. We're the ones making the investment decisions in practice. The investors in the fund are just a very large North American financial institutions, mainly pension funds, endowment funds, that people who are used to investing in private equity or similar investments, but things that take a long time to mature.
How about Latin America?
Well, as you know, we've been successful against Latin American states.
But did you get the money back?
We're trying. It's Venezuela, so it takes time. It's not easy.
But you are dealing with really very difficult states, because when you come, you are financing Venezuela, Argentina, and things like that. I mean, my question is, are you really expecting to get money you are looking for?
Yes. but the truth is, take the Venezuela example, we started financing that case nearly 6 years ago. And Venezuela was a different country 6 years ago. Its bonds traded at par. Oil was, although it's going back there, and Hugo Chavez was in charge, and they had tens of billions of dollars of cash. Now they don't. It's a different story.
So I understand then that you are not only interested in commercial arbitration, but in investment arbitration.
Yes, definitely. Mm-hmm. Yes, but arbitration in general is probably half of what we invest in, and then slightly more investment arbitration than commercial arbitration.
What is your position vis-à-vis the Spanish kingdom after Achmea decision in the tribunal? I mean, do you think that it's a risky business now to finance investment arbitration against Spain?
Yes, it is a risk now. We've talked about this before, but to me the key risk will be how the US courts approach recognition and enforcement. In the context of ISA, I think will be the first hearing that's heard on that. Mm-hmm. And that will dictate a lot. But things are definitely more difficult now, there's no doubt about that.
And do you think that being an arbitration, not from a bilateral treaty, intra-community bilateral treaty, but ECT, Energy Charter Treaty, it's modifying the risk, or?
Yeah, we've avoided the bilateral risks. The ECT risks are ones we would still consider. We think that obviously it's a better position, but it's clearly not perfect anymore. No.
So Spain is a risky country to finance?
For those, well, with an intra-EU, mm-hmm. Yeah. There are investors from outside the EU as well.
I understand that going away from arbitration, you are financing litigation as well in Spain. What is your interest in that? Because normally litigation in Spain takes a long way to get to the final decision. Are you financing local litigation as well?
We are, but as to date we've tended to pick situations that are quite well developed. So they've done 10 of the 12 years already, or whatever it is. So we've tended to look for situations that are later stage. Sometimes they're even post-judgment and pre-cassation, for example, where claimants have actually got a judgment and they need finance, and they've been waiting for 10, 12 years. They've got litigation fatigue. Mm-hmm. And that's a very good situation for us to get involved, because you're investing into something that's less risky, mm-hmm. And therefore the pricing is cheaper for the claimant, so it's more interesting for the claimant. So that's, and we're actively looking at a few situations. Some of those situations are very, very large, mm-hmm. hundreds of millions.
Good. I think it's a good moment for the audience to put some questions. It's not easy. It's not so frequent to have a funder to be cross-examined. Please go ahead. Microphone.
Ja, viene.
Thank you. I've had experience with CFAs and insurance. Do you have any element of insurance in what you do? Do you reinsure your risk in some stage, or what's the connection? Do you have any connection between CFAs and insurance and what you do, your financing? Thank you.
So the question is, do we reinsure our risk or use insurers in some capacity? The answer is in general no, because our investors, they sort of pay us to take our risk. They're not looking for us to take a risk and then lay that risk somewhere else. The one exception is in the English market is because we have a very strict adverse cost regime, and a funder can be directly liable in the English courts for adverse costs, whether you assume the risk or not. So there are two ways of approaching that. You would say to the claimant, either you charge the claimant more because you're taking that risk, or the claimant says, well, there's actually a very deep insurance market in England and I would prefer to lay that risk with the insurance market, and then we would lay our risk with the insurance market as well. But that's the only, other than that, we tend not to.
A question.
And there's Jose as well.
Good morning.
Hi.
Hi.
Pueden preguntar en español porque entiende el español perfectamente. Es decir,
Como ayuda.
I'm happy to do it in English if it's
Even better.
easier for Mick.
Yes.
Okay, my question has to do with something that has been discussed in some of the previous panels. It's been mentioned that a number of arbitrations end before getting an award through an agreement, okay? And I'd like to understand how your position works when an agreement is reached. I am presuming that you still get your slice of the pie, okay? And in that case, and this is where my question is actually going, would you have an incentive to actually favor an agreement to finalize the litigation process, the arbitration, earlier?
It depends on the finance agreement.
It does, but you're right. Sometimes it would be, it could be in our interest. If we had an agreement where we simply got a fee that was 3 times the amount we invested, then we don't care whether the claimant gets 10 or 100. But we tend not to enter those agreements to avoid that problem, and also because what you want to create is an alignment of interest between our fee and the claimant's success. So really we always want to be in an agreement where there is a material percentage interest for the funder. So the funder is aligned with the claimant, and the idea is to get the most attractive return possible. And that still might be settling it. And then what happens, because the claimant has control, the claimant says, okay, I might settle this, but you need to take a discount, Mr. Funder, and then we negotiate. That's what happens in practice.
There was another question here.
Thank you.
Jose.
Gracias, Bernardo. José Rosell. Mick, how often do you finance, or your fund finance adverse costs, and in which cases do you agree to cover adverse costs in arbitration?
I think I would describe it by historically, we're investing our 3rd fund now, but in our 1st fund, I don't think, maybe with one exception, in a dozen cases we financed adverse costs. In Fund 2, it's been nearly 50% of the cases we've taken some level of adverse cost risk. And I think in Fund 3 too. So it's quite a common part of what the claimant asks for now, is that they're attuned to the adverse cost risk. And it's also good for us because it helps develop the market. If you think an average case an average case might take 2 million of cost to run it, but there's another 2 or 3 million risk of losing, and the claimant therefore wants you to take 4 or 5 million of risk. That means we have more opportunity to invest money. So if we like the case, and we think the damages are good, for us it's an opportunity to take more risk if the case warrants it. So it's a welcome development. But some companies, a lot of claimants in these Spanish cases are of the view that the adverse cost risk won't be enormous because the state hasn't used expensive external counsel, for example. Now that may or may not be true, but there's a view there, yeah.
How creative you are in your financing decision? I mean, for instance, if you see a good case, do you propose to the clients to participate in their business?
No, we're litigation risk only. So we generally avoid taking business risk. But what sometimes happens is a claimant comes to us and says, okay, I need 2 million for the arbitration, I need 2 million for adverse costs, but I also need 5 million of working capital for my business. Mm-hmm. Can you finance that?
You are prepared to do that?
And we do that, yeah, we do that regularly, yes.
And do you purchase arbitration awards?
Yes.
Yes?
Yes, or generally finance them through, I mean, there's a legal risk involved, I think, in doing an assignment, a true assignment of an award before it's been confirmed at the seat, say. Mm-hmm. But you can achieve the economic equivalent of an assignment.
And in some cases, do you syndicate your participation with other funds?
Yes, yeah, for the bigger amounts, yeah. Once you get into the world of people wanting to invest 20, 30, 40 million, you would generally look for a partner. So yeah, we've done syndicated deals.
Mike, I've been seeing people from the other side telling us that the coffee is waiting for everybody.
Excellent.
We thank you very much for your presence here. It was really very, very interesting, and we wish you a very good luck in your activities in Spain.
Thank you very much.